All right, so today's presentation this month commemorates the 186th anniversary of the signing of the 1839 Act of Union, an act that unified two branches of Cherokee people into a single Cherokee Nation government. And today we are going to hear about this historic meeting from first Jack Baker, who is tribal historian. We all know Jack, president of the National Trail of Tears Association. He is a former president of the Oklahoma Historical Society and also a current board member. And then after that, we will listen to what all of this means today from Chrissi Nimmo. She is the Vice President, Associate General Counsel of Cherokee Nation Businesses and former Deputy Attorney General of the Cherokee Nation. So please give them a round of applause, and we'll go ahead and get started with Jack. Thank
you. In the last week, the last detachment of Cherokees have finally arrived. So this is Sunday, 24th of March. So that now the immigration, which began on 1st of September of last year, has now reached its end. And the 15 or 16,000 Indians are now in their new homeland here in the West. In a margin note states the entire Cherokee Nation, including those who are already living here in the West, now amounts to about 23,000 souls. And may God grant that they may possess this land a right long time, and that they may become prosperous and a happy people here. 1st of April. So during this past winter, our Indians were busy getting land ready to sow with corn, and it's getting time for planting now. But not much can be done with cultivating the corn this year, however, since they're still busy with building their houses and other work. And most of them are still getting sick with the fever from time to time. So the people also began to rebuild their homes and farms. And the two governments also worked to build the government into one. So on April 23rd, 1839, Chief Ross wrote to the three chiefs of the old settlers, John Brown, John Rogers, and John Looney. And Ross suggested that a joint council be held to discuss what kind of governmental structure was needed to reunite the Cherokee people. He wrote, "We are all of the household of the Cherokee family and of one blood. Therefore, together, they should take measures for cementing our reunion as a nation by establishing the basis of government." The old settlers agreed to meet, and on June 3rd, 1839, over 6,000 Cherokees assembled at the Tahlequah campground, which is 4 miles northwest of Tahlequah. John Brown, the principal chief of the old settlers, addressed the gathering. He says, "We joyfully welcome you to our country. The whole land is before you. You may freely go wherever you choose and select any places for settlements which you may please. You're eligible to any of the offices. Next July will be an election for members of both houses of our legislature. At those elections, you will be voters. It is expected that you will be subject to our government and laws." And for the immigrant Cherokees, this was very problematic. Brown spoke of the area as our country, which implied that the new immigrants were being admitted as a privilege and not as a right. More disturbing was the implication that the new arrivals had no government of their own and would submit to the government of the old settlers. This was in direct opposition to the resolution passed in the East on August 1st of 1838. It also meant that the majority of the Cherokees would be governed by the minority. And on June 10th, John Ross explained to John Brown and other leaders of the old settlers that they could not accept their terms. Brown responded that for all matters going out of removal, the immigrants would be allowed their own chiefs, committee, and council, with the name being the Eastern Cherokee Nation. Brown proposed that there be two governments in the same territory. And on June 20th, the Council of Tahlequah was declared by the old settler chiefs to be over with without there being a resolution of the problem of the two governments. But before everyone had left, however, two Cherokees whose fame and popularity transcended party lines, Sequoyah and Jess Bushyhead, called upon the people to meet again on July 1st to reunite the Cherokee Nation. And on June 22nd, principal leaders of the Treaty Party, Major Ridge, John Ridge, and Elias Boudinot, were all executed for their role in signing the 1835 treaty. But despite this, the council called for by Bushy Head and Sequoia convened at the Illinois campground, which was a couple of miles north of Park Hill. And only about 2,000 Cherokees attended, with probably less than 150 of them being old settlers. The only old settler chief to attend was John Looney. An act of union was approved and signed on July 12th by the immigrant Cherokees, but the old settler Cherokees had not yet agreed to it. And the Moravians give the following account in their journal. Sunday, 28th of July, 1839. Mr. Bushy had called on us on his way home from the council, and the hope for a brotherly agreement among the various parties of the nation appears to be better now. However, everything is still very uncertain, and for our part, we can only watch in stillness and patience, and diligently beg the Lord for help for this poor, disowned, and disinherited people. 19th of August. In the evening, Mr. Butler and Brother George Hicks came to visit us. From the latter, we received the news that the long-awaited unification of the parties in the nation is about to be realized. So the old settlers agreed to the Act of Union and signed it on August 23rd of 1839. Part of this union states, whereas our fathers have existed as a separate and distinct nation in the possession and exercise of the essential and appropriate attributes of sovereignty from a period extending into antiquity beyond the records and memory of man, and whereas these attributes, with the rights and franchises which they involve, remain still in full force and virtue, as do also the national and social relations to the Cherokee people, to each other, and to the body politic, excepting in those particulars which have grown out of the provisions of the treaties of 1817 and 1819 between the United States and the Cherokee Nation, under which a portion of our people were removed to this country and became a separate community. But the force of the circumstances having recently compelled the body of the Eastern Cherokees to remove to this country, thus bringing together again the two branches of the ancient Cherokee family, it has become essential to the general welfare that a union should be formed and a system of government matured, adapted to their present condition, and providing equally for the protection of each individual and the enjoyment of all his rights. Therefore, we, the people, composing the Eastern and Western Cherokee Nation, and National Convention assembled by virtue of our original and unalienable rights, do hereby solemnly and mutually agree to form ourselves into one body politic under the style and title of the Cherokee Nation. So this act of union paved the way for a constitutional convention and the adoption of a new constitution on September 6, 1839. And the Moravian missionary Miles Vogler gave the following account in a letter to Reverend Schultz in Salem, dated October 8, 1839. It says, I am very glad to inform you at this time that a kind of union has taken place between the old settlers and the immigrants. I was at the council on the 4th, at which time the new constitution was laid before the convention by Mr. Ross. This convention consisted of 50 persons. 25 were old settlers. So this was new information we didn't have until this had been translated, that the Constitutional Convention of 39 consisted 25 old settlers and then 25 of the immigrant treaty party. But after the convention read the Constitution and made some necessary amendments, it was presented to the people, with whose approbation it met and consequently was adopted. After this, the people elected their officers. John Ross, of course, was appointed principal chief. Joseph Van, second principal chief, and not the one who formerly lived at Spring Place, because the Moravians were well acquainted with the Joseph Van there, but this is Joseph Van, who was the son of Avery Van, and Avery was an old settler. Major Lowry, Richard Taylor, and George Hicks refused to hold any offices. The members of the council and the committee are mostly all strangers to me, and I suppose we to them. Mr. Ross's council will adjourn this week after a long and tedious session. Mr. Brown is trying to hold a council which was to commence this week. I do not know who will attend it, as the majority of the old settlers have united themselves with Mr. Ross. Perhaps some of the treaty party will join Brown, but if they do, it will amount to little. Jack Bell and Stan Wadey are going to Washington as the delegates of the treaty party. Signed, Miles Vogler. So thus our new Constitution was implemented and remained in place until 1975, when a new Constitution was passed by the people. And our nation was on its way to being rebuilt. And the blessing asked for by the Moravian missionary in April of 1839 has come to pass, where he stated, "May God grant that they may possess this land a right long time, and that they may become a prosperous and happy people here." Thank you.
All right, very informative. So we're going to welcome up Chrissi, Ross, Nimmo, and inform us about what this means for us today. Thank you.
So I'm going to talk about everything that happened in the following 186 years in 10 minutes. I kid. When we talked about this before, I found it really interesting. The Act of Union is really short. It's not even 2 full pages. And Jack, as a historian, when he pulled out parts of it to read, he pulled out separate parts than I, as an attorney, pulled out to read. So the part that you haven't heard in the Act of Union said, "All rights and titles to public Cherokee lands on the east or west of the River Mississippi, with all other public interests which may have vested in either branch of the Cherokee family, whether inherited from our fathers or derived from any other source, shall henceforth vest entire and unimpaired in the Cherokee Nation as constituted by this Union." One reason that that was so important, because 6 months prior to the Act of Union, the land patent to the Cherokee Nation Reservation was issued in the name of Cherokee Nation. So they said, land that we now have, land that we may have in the future, regardless of how we obtain it, it is all that of the one now Cherokee Nation. And as we heard Chief say in the video when we started, the Act of Union was important for what came after it. Up until that point, there had been treaties with the Cherokee who were in the east. The illegal treaty that moved us here. But there were further treaties happening. And part of that was following the Civil War. In 1846, we had a treaty. The Cherokee Nation Act of Union was internal. Although there may have been outside pressure, there wasn't any outside influence. There was no one telling the 2 factions of the Cherokee Nation, you have to come together, you have to agree, you have to settle this. We decided for ourselves that in order to move forward, we had to move forward as one Cherokee Nation. But as you heard Chief say, it wasn't exactly settled, even though both sides had agreed and signed, because there were still, let's say, disagreements about things going forward. But in 1846, the very first treaty that was signed after the Act of Union, so after all Cherokees were in Oklahoma, Act of Union, one Cherokee Nation, in addition to the Act of Union, there was language in the Treaty of 1846 that said all difficulties and differences heretofore existing between the several parties of the Cherokee Nation are hereby settled and adjusted. So we had the Act of Union ourselves, but then we had the United States recognizing through the most recent treaty that there was one Cherokee Nation, and whatever disagreements may have happened in the past had been settled. We then had the Civil War, where there were what I will also call legal treaties, because they were with the South, who was not a legal government, at least at the end of the Civil War. So there were treaties there, and immediately following the Civil War was the Treaty of 1866, which was the last treaty the Cherokee Nation signed. It is a treaty that gives us the boundaries of the Cherokee Nation Reservation that we have today. And in that treaty, it reaffirmed, as they often did, all other provisions of previous treaties that weren't in conflict with the 1866 treaty. So this language that all difficulties are settled between the Cherokee was re-recognized via the 1866 treaty. And the reason that treaty is important and the reason who is a treaty party is important is because there are so many things happening today that still relate to those treaties. Again, the reservation boundaries of the Cherokee Nation, which following the McGirt decision and its progeny are very, very important to us today. The recognition of freedmen as citizens of the Cherokee Nation, that was language in the 1866 treaty. The recognition of Cherokee courts and their continued exclusive jurisdiction over some cases, including civil cases between Cherokees. And again, the reaffirmation of previous treaties. Those provisions include delegate to Congress, hunting and fishing rights, courts of the Cherokee Nation, right to water usage, health and welfare of the tribe, which is general language and treaties that the United States government agreed to provide for the health and welfare of tribes are language that's still used today, for example, for IHS funding, because the United States government said, we're taking your land, we're forcing you to go somewhere else, and we are going to continue to provide for your people. And part of that trust relationship and what comes out of that is their obligation to help pay for things like health care and education. So these are all, even though they are old promises, they're still promises, and we hold the federal government to their promises. And to be the party that was a signatory to those treaties means that you are the tribe that gets to enforce those rights. So that happened all within the 20 to 40 years following the Act of Union. I said I was going to cover 186 years, but I'm really not because I'm going to skip ahead a little bit. And I want to talk about modern recognition of Cherokee Nation as the treaty party to every treaty that the United States has signed with the Cherokee people. There's a couple of things I'm going to talk about here. The first was Supreme Court in 1970 when the case began. It was the Arkansas Riverbed case. And when the tribe, the three tribes involved in that, Cherokee, Chickasaw, and Choctaw, when those tribes were granted fee patent to the land that they still have as their reservation today, they got everything inside of it. We know now that those lands, most of those lands were allotted to individual citizens of those tribes. But part of the allotment was any land that was not allotted to individual citizens and not sold by the tribe through that process remained the property of the tribe. And this became important in the riverbed cases because the three tribes sued and said, we own the riverbed. This land was given to, exchanged for, removal here, to the three tribes. All of this land was allotted. The river was never allotted, and we own that. And that's important because if you own a navigable waterway, you have a say in what goes on there, including removing sand and gravel, getting easements across the river. So if you think about the Arkansas River, when a road has to be built across it, or power lines have to go across it, or other types of utilities, the owner of that has to give permission in order for that to happen. And for many years, it was acted as if the state of Oklahoma, and in some cases Arkansas on their side, were the owners of the Arkansas riverbed. And the United States Supreme Court said, no, the tribes own that. And then we thought, oh, well, what do we do now? Because we've been acting as if the state of Oklahoma owned that. So throughout this litigation, and in order to settle the litigation, there was a congressional act passed regarding the riverbed. And when Congress passed the riverbed settlement, and this was both for reparations for money that should have gone to the tribes that had gone to other places, and going forward, recognizing that the tribes had the jurisdiction to determine the rights of the riverbed. But in 2002, when Congress passed the Riverbed Settlement Act, the congressional finding, which is part of the federal law, says the Cherokee Nation, a federally recognized Indian tribe with its present tribal headquarters south of Tahlequah, Oklahoma, has maintained a continuous government-to-government relationship with the United States since the earliest days of the Union. So this is congressional recognition that the Cherokee Nation that we, Congress, ratified treaties with for 150 years is the same Cherokee Nation that exists today in 2002 with its headquarters south of Tahlequah, Oklahoma. So that's a very modern day recognition that yes, this is the same treaty party. Yes, that is the same government. Yes, that is the same reservation, where we see these disputes, specifically with states' rights flowing out today. One of the things that we know now did not disestablish or abolish the Cherokee Nation was the Curtis Act. And that's been an argument for a long time. It was the original primary argument in the McGirt cases. The state of Oklahoma said, well, of course we have jurisdiction over Indians who commit crimes within the state of Oklahoma because there are no longer reservations in the state of Oklahoma because the tribes themselves were abolished by the Curtis Act, therefore their reservations were abolished. That was their number one argument. And the Supreme Court in the McGirt case said no, the Curtis Act did not abolish tribes. It hamstringed them for sure, but it did not dissolve them and it did not dissolve their reservations. The state of Oklahoma also argued during the McGirt cases that simply by forming the state of Oklahoma after the tribes were granted reservations, somehow abolished or disestablished those reservations. Their argument was, yeah, you had a reservation there when it was in Indian territory, but then it became a state, one of the United States of Oklahoma, and therefore you can no longer have those reservations existing when you admitted Oklahoma to the Union. The Supreme Court also said, no, that argument doesn't work either. There's specific language in the Enabling Act, in the Oklahoma Constitution, that recognize tribes, recognize reservation, recognize Indian land. As I talked about, there were other rights mentioned in treaties that the signatory to those treaties have a right to, hunting and fishing. When we talked about this last year, we were just coming off of the announcement of the agreement between the 5 tribes to allow members of one tribe to hunt and fish on reservations and members of the other tribe. But the reason that hunting and fishing rights are litigated, not just in Oklahoma, there's long-standing across the country, is because most tribes in their treaties have some type of language about the right to hunt and fish and use the land in their reservation, Indian country, tribal territory, whatever it's called there. But we are able to point to our treaties and that we are a treaty party and this is our reservation via treaty to say we have rights, even if they're not written in federal law, even if they're not written in state or tribal law, we have inherent rights by ownership of the land to hunt and fish here, which is the reason if you're a Cherokee living within the reservation, you can show your blue card and you don't have to have a hunting or fishing license to fish on the land and the waters of the Cherokee Nation. Taxation. We had something newsworthy last year that had just happened, and this year we have the Strobel case. That was a case where a member of the Muskogee Creek Nation who lived and worked on the Muskogee Creek Nation argued that the state could not tax her income, and the Oklahoma Supreme Court just ruled on that case. They said that the state could tax her income. I don't have any inside information, but I would guess it's not the last we've heard about that case. But whatever the case is, there are other areas that we know where taxation is settled. Taxation of motor vehicles and gasoline, where we've entered compacts with the state of Oklahoma because it's settled that the state of Oklahoma cannot tax certain things by tribal members on their own reservation, or sometimes other Indians on their own reservation. So again, those are very current modern day issues that are still working their way through courts that are vested, most of them, in treaty rights of tribes, especially on their own reservations. I know Chief talked a little bit about, in his video, about claims by Eastern Band and UKB that they have treaty rights, that they are treaty parties. And there are other places in history where courts or Congress or others have taken the position that Cherokee Nation takes, that we are the only treaty tribe, and that those tribes don't have rights that were guaranteed to the Cherokee Nation in their treaties. As early as 1886, the United States Supreme Court found that the Eastern Band was not entitled to funds owed to the Cherokee Nation in exchange for lands because of treaties, because the Eastern Band had not relocated as part of the treaty that ceded the land in the East, that they had stayed there. And the Supreme Court said, no, you are a different group, a different band of Cherokee people. You do not have legal rights to this money that is owed to the Cherokee people who exchanged their land for land in Oklahoma, and there were payments as part of that. for the United Ketua Band. There's never been a court or congressional finding that the United Ketua Band was a treaty party to the Cherokee Nation. There has been argument in the past about a Ketua Society that was incorporated in 1905 prior to statehood in Oklahoma. We found those records in the Cherokee County Courthouse, and there was a Ketua Society that was incorporated under federal law, but there was no state law. The laws of Oklahoma applied in Indian Territory because they hadn't written laws the laws of Arkansas applied in Indian Territory because the federal government had not written laws for Indian Territory. And at that time, this was, if you think of the way a modern day kind of 501c3 would have to register, the Ketua Society was a benevolent society, much like the Masons who registered at the same time. It was a way to be recognized as a legal organization, and under the law, it was for benevolent purposes.